Dang, it's hard to believe we're almost done, but here we are to chapter 20. We've gone through an awful lot, and we actually have a little bit to go through yet. And here we're going to talk about discrimination in business, and it's a huge topic. I think if you asked any HR person, you know, the time they spent on compliance and those types of things, and working with or avoiding, you know, claims of discrimination is probably ends up being a way bigger share of their time than what they'd like to. I'm sure that they would like to spend more time on training, developing, you know, pushing or making their employees better, etc. But they end up spending a lot of time on this, and partly because the laws are complicated, and partly because a lot of discrimination and those things still exist, whether they be overt or not. We'll talk about that a little bit. So the timeline, and I don't know that any of these dates are particularly critical, except this one, okay? Title VII of the Civil Rights Act of 1964, okay? Know that title. You know, it'll be on the test for sure, okay? It's huge. Some of these others may be on the test, but I may be a little less concerned about knowing and understanding. I'm sorry, you'll certainly want to understand them, but knowing what the dates were that they were passed. But Title VII of the Civil Rights Act of 1964, and I keep saying Title VII because the Civil Rights Act itself was far more broad. Title VII dealt with employment issues, so a little bit dated, okay, but oops, let's go back. I'm sorry. You know, and these are total numbers. These aren't in thousands or anything like this. So you can see the EEOC joins with plaintiffs on occasion. Okay, it's not all that often in lawsuits that are actually filed against companies. It's like many other things, you know, so many of these get settled out of court or they get settled with consent decrees, those types of things. When an employee accuses an employer, you know, the EEOC often steps in, examines it. You know, if they find that the employer is at fault, you know, and they tell the employer, hey, we're going to take the employee's side, you know, and we need to either figure this out or we're going to go to court, you know, often they figure it out, right? And what are the things, you know, that get sued in Title VII? So discrimination, okay, based on race, color, religion, et cetera, et cetera. ADA, which American with Disabilities Act, ADEA, or age Discrimination and Employment Act, the EPA stuff. That's kind of interesting how that ends up being in there, and then other statutes. So Title VII of the Civil Rights Act of 64 prohibits what kind of conduct, and again, the important thing for Title VII is that that's discrimination in employment. Okay, it actually did not, at least at the time, address age discrimination. Well, you guys can kind of take a look at that. So, who's covered, right? Employers with 15 plus employees. That doesn't mean smaller employers can discriminate. They're probably going to have more problems proving a disparate impact or those types of things, and so, you know, smaller employees do get some breaks definitely when it comes to these things. And originally the provisions of Title VII covered these five things, these five protected classes, and so know these for sure: race, color, religion, sex or gender, and national origin. Okay. Know those for a fact. They'll be on the test. Those are the five original protected classes under Title VII of the Civil Rights Act of 64. Now, there's an exception for bona fide occupational qualifications. And what do we mean by that? And yeah, I put this picture on there at the risk of all kinds of things, but part of it is because it is to make a point. Bona fide occupational qualifications can be a number of different things. Certainly, if you're in a work environment that requires strength, maybe a landscaper, right? People have to be able to lift, you know, heavy bags of fertilizer or rocks or whatever, okay? That's a bona fide occupational qualification. You can discriminate based on that, okay? There was one case, it was Greyhound buses, you know, and nowadays, especially in Montana, I don't think there is any bus service other than local bus services almost any place here in Montana, but there's still an active Greyhound bus, and it's in bigger towns and whatnot, between bigger towns and cities. And Greyhound bus had a restriction on the ages that they would hire their drivers, and they were sued. They said it was age discrimination, but they proved that drivers at up to a certain age were safer. Okay, above a certain age and then up to a certain age were safer drivers, and as a result, they won their case. Okay, so the government said they were allowed to discriminate. Okay, I put the picture in here because it's Hooters, right? So is Hooters allowed to discriminate? And there was a case. They were sued. Okay, the case ultimately was settled. Okay, so again, it was an administrative action. It was the EEOC, and Hooters were kind of getting in a little bit of a battle over it. And Hooters agreed to make some changes in their hiring practices, but not necessarily for servers. Okay, so in essence, I guess there are bona fide occupational qualifications that still exist at Hooters. Okay. And so it can be a wide range of things, but they have to prove that they're meaningful to the business, either the profitability of the business or to the safety, as in the case of the Greyhound. I imagine railroads, those types of things would have those things. So types of things that are prohibited, the way we discharge or fire people, refusal to hire, okay, compensation, of course, terms, conditions, or privileges, and those could even be small things. So enforcement comes through the Equal Employment Opportunity Commission, or the EEOC. Remedies can include things like back pay or injunction, compensatory, punitive damages, job reinstatement, those types of things. Charges have to be filed within 180 days, and this has changed a little bit. Won't be on your test, the 180 days you might need to know, but it was 180 days of the incident, but I think it was the Lily Ledbetter case, and she actually, there was an incident that occurred. She was discriminated against, but she continued to work at the place and eventually quit. I don't know if it was a year later or half a year later, and then filed her charge. Well, it was more than 180 days after the incident, but it was within the time she had quit. It was no more than 180 days had passed, and the court ruled that her case could go forward. So the 180 days has changed a little bit from the incident to the incident and or maybe your last day at work, and I think it's become a little bit more of a gray area. So discrimination claims are wrongful discharge or unfair dismissal, breach of contract that you might have between the employee and the employer, wage issues, okay, one person being paid more than another probably, race discrimination, whistleblowing, sex discrimination, disability, or equal pay concerns. So the three main ones, that we look at are disparate treatment, okay, where an employer intentionally discriminates. So that's an overt type of discrimination where, we might hire a person and not hire an equally qualified person who's of one of the protected classes. Again, being that be that race, religion, those things, right? And that's overt, okay? Or hiring a man versus a woman, even though the woman might have been more qualified, right? Disparate impact is a little different. We'll talk more about this, but it's basically a practice that's maybe unintentional, and yet it leads to a discriminatory impact on some of those protected classes. And then retaliation, of course, is adverse action against employees who may, file claims. Let's stop there, and we'll come back and talk a little bit more in our second segment. So.